that is a new development that's coming, which was not there when the ruling was made. It was the opposite. Now, the question is, in light of this new development, is the tribunal inclined to persist with the ruling, or is the tribunal inclined not only to listen to this new development, but also to consider it, and having considered it, feels persuaded to move from the default position to a public hearing? I make this point because let us be very clear about this. The ruling was not necessarily meant to protect a particular individual, but the image of the judiciary, which was why the law says, as the president of the tribunal, I must consult with the Chief Justice on this issue, because the Chief Justice is the ultimate protector of the image of the judiciary. Now, we have noted your point. I think this is the same point that you made when we were in chambers, essentially, namely that your client no longer, for whatever reasons, no longer objects against the matter being heard publicly. And I must put a rider there that we note and respect your client's position. We don't want to go into the reasons why, because we may find that some of the reasons, including what I would describe as imagined problems as a result of a hybrid situation, may actually not arise. But that is besides the point. The important thing is you are saying to us, for whatever reasons, your client has no objection against the matter being heard in public. And that's the point on which you came to see us. You haven't added anything to it. You have succinctly summarized what you have told us in chambers. It is important for me to emphasize that what you have just said is exactly what told us in chambers. Because after you told us what you said in chambers, in accordance with the Act, I reconsulted with the Chief Justice telephonically, because I'm required as the president of the tribunal to determine the procedure as to whether in camera or public. I must do that in consultation with the Chief Justice. If you are to address to me now and I suddenly decide otherwise, it will be irregular. So on the basis of what you told me, I reconsulted with the Chief Justice telephonically and presented the facts to her. And after that consultation is going to be born, possibly, an amended ruling. But that's the procedure where it is now. But I think some members may want to ask questions to you about this.
I just want to know, why did you wait until such a late stage? Because this has been ongoing for quite some time, and now right at the beginning of the hearing, you come and you request that it be, I think on the 9th of January, whilst the ruling was given, and nobody said anything about it. And the ruling was given to protect the judiciary more than it was to protect your client, I think. But your client was protected because the ruling was in favor of your client as well. But I just wanted to know, why did you take so long to come to this decision? I mean, your client has been represented by senior counsel throughout.
Thank you, Judge Torres. I appreciate that. I appreciate it. I don't even want to use the excuse that I was briefed the day before Christmas. I'm new in the matter. It's no sufficient reason. But preparation for a hearing sometimes is the one that reveals certain things that may not assist in determining a matter. And I think this was birthed by that kind of preparation, apart from the fact that I was new and have a different perspective about how practical this would be. So while I apologize for my client that it was raised rate and my attorneys, but it was not because of any shoddiness. It was because in preparation in getting to deal with this use, you certainly have to take into account the prejudices, the impracticalities of doing things. And lastly, I'm not the determinant of this, and you also have to consider what exactly is in the interest of the judiciary. Is it when something is hidden and therefore there is speculation out there about it, or is to open it up for people to see what it is that is being dealt with so that they can trust the process? So it was a combination of all of those, but really about why it was late, I think it's partly because of the intricacies of preparing for something that is like this, that's emotional, that's detailed, that no one knows which the right way to do them. And my late involvement, which came with another perspective that, well, I don't think I can cross-examine to and fro, in and out, public and not public. Those are my submissions.
Thank you, Mr. Sikakane.
Thank you.
Well, we understand you came late in the matter, Mr. Sikakane, and it's a complex matter with many ramifications. Now, here comes the ruling or non-ruling. This morning, as we commence proceedings, Advocate Sikakane for the respondent asked for an adjournment so that he could come and see us in chambers about a particular issue. We duly adjourned, and he came to see us in chambers, and it turned out that the issue that he wanted to raise was exactly the issue that he had just raised now as a result of my giving him the floor, which, as we all know now, is that his client's position, that is the respondent's position, has changed from opposing the matter being heard in public with the media allowed to the opposite direction, to say that let the matter be open to the public in all respects. And after he had told this to the tribunal in chambers, as the president of the tribunal, and indeed as required by law, I duly consulted, or to put it properly, more accurately, I duly reconsulted with the Chief Justice telephonically about this particular issue. We did have quite some substantive discussion about this particular issue. But at the end of the day, we have come to a conclusion, which I'm now conveying as the president of the tribunal after that consultation, which is that the matter will be heard in public. The entire matter will be heard in public. The ruling, as my colleague has indicated, was emphatic about protecting the image of the judiciary. But we do not want to pretend, by we I mean me and the Chief Justice, we don't want to pretend to know the parties' case better than the parties themselves. If both parties, including the one we had objected against, then the matter being heard publicly is of the view that it will not harm the public if the entire matter is heard in public, precisely because we don't know every aspect of their case at this stage. We feel persuaded towards inclining to allow the matter to be heard in public. I think that explanation was given, and should the need arise, more reasons may be given. But suffice it to say that after that reconsultation and bearing in mind the position now lately adopted by the respondent, who must be fully conversant of every single merit of their case, of his case, we are inclined to do so. Accordingly, the following ruling is made. The hearing of this matter will be held publicly. Thank you.
Thank you, Chair.
Advocate Skippers.
Thank you, Chair. I've prepared an opening statement just to place ourselves up to speed of what this tribunal is going to take on. This proceedings that commences here today before this tribunal are unprecedented in the history of South Africa. This is the inaugural instance in which the tribunal has been established to investigate allegations of sexual harassment against a sitting judge of President of the High Court. This has never been done before. This tribunal was established pursuant to the Judicial Service Commission Act, following the ruling by a Judicial Conduct Committee appointed by the former Chief Justice. The then Chief Justice established the JCC in terms of Sections 8, 9, and 10 of the Judicial Services Commission Act. The JCC then conducted a process in terms of Section 16.4 of the JSC Act to determine whether a prima facie case of misconduct had been established against Judge President Mbenenge, and to further determine if that conduct amounts to gross misconduct. Having concluded its process, the JCC then found that the complaint establishes a prima facie case which, if substantiated, is likely to result in a finding of gross misconduct. It therefore recommended that this tribunal be established in terms of Section 19 of the Act. In accordance with Section 25.1 and Section 26 of the JSC Act, and as mandated by Chapter 3 of the Act, this tribunal has been established with the responsibility of regulating these proceedings and conducting an inquiry into the allegations of misconduct, gross misconduct, by 1, collecting evidence, 2, conducting a formal hearing, 3, making findings of fact, and 4, making a determination on the merits of the allegations. The complaint before this tribunal is that Judge President Mbenenge sexually harassed the complainant and that this constitutes gross misconduct. The complainant asserts that she endured sexual harassment in multiple forms, including the receipt of sexually suggestive messages through social media, and that will be on the platform WhatsApp, inappropriate comments and gestures regarding her physical appearance made in person while at court, and a specific incident within the Judge President's office during which he made sexual remarks and gestures of a similarly inappropriate nature. The Judge President has already admitted to engaging with the complainant on social media platforms in a way which was clearly sexual and clearly inappropriate for the most senior judge in the division. Furthermore, it is important to note that the complainant is among the most junior members of the court administration. The inherent power imbalance between the complainant and the Judge President is a critical factor in understanding and evaluating the evidence to be presented during these proceedings. The evidence before the tribunal. The complainant will provide testimony before this tribunal which will establish that the engagement between herself and the Judge President occurred without her consent. Her account will clearly demonstrate that the interaction was not flirtatious but rather was unwanted by her. She will testify that she tried to make this clear to the Judge President on several occasions, but the Judge President intentionally disregarded her boundaries and persisted in his pursuit of a sexual relationship with her. It is the responsibility of this tribunal to fully comprehend the complexity surrounding sexual harassment and sexual violence, particularly in the workplace, and to evaluate these claims through that nuanced lens. The tribunal must take into account the significant power dynamics at play in this case As a judge president, he holds substantial influence over the entire judiciary in the Eastern Cape. Despite this power, the judge president never sought to establish whether the complainant was willing to engage in a consensual relationship. Instead, the complainant will testify that when she requested a meeting with him to address his inappropriate behavior, she ultimately withdrew her request after the judge president reiterated his desire for intimacy, even though she had explicitly rejected such advances on more than one occasion. It is crucial for the tribunal to recognize that sexual harassment is not a neatly defined or straightforward complaint. It will be like no other complaint a tribunal of this nature has had to investigate, as sexual harassment and sexual violence often happen in secret, especially in the workplace. This secrecy often affords perpetrators a sense of impunity and casts doubt on the credibility of complainants when they eventually come forward. During the course of these proceedings, several witnesses will be called to testify. These may include current judges from the Eastern Cape Judiciary. While these witnesses may testify what they heard or were informed of, none will be able to offer direct knowledge of whether the alleged sexual harassment took place. If we look at sexual harassment within the South African legislative framework, sexual harassment is a well-recognized issue within the South African legal landscape, and its definition is outlined in the new Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace, dated 2022. The Code defines sexual harassment as unwelcome conduct of a sexual nature that infringes upon an employee's rights and creates a barrier to equality in the workplace. Key factors in evaluating such conduct include whether the harassment is based on prohibited grounds such as sex, gender, or sexual orientation, whether the conduct was unwelcome, the nature and the extent of the conduct, and the impact the conduct had on the employee. South African jurisprudence has developed a robust body of case law that interprets sexual harassment and examines its underlying causes and consequences. Through a testimony, the complainant will illustrate that the judge president's conduct was of an explicit sexual nature, unwelcome per her, and impacted on her ability to work in a safe and dignified environment. Her evidence will show that there is a common thread throughout the WhatsApp messages, being that the conversations were one-sided and always initiated by the judge president. The evidence presented will guide the tribunal through the WhatsApp exchanges between the complainant and the judge president. This evidence will reveal a distinct pattern in the judge president's behavior. The judge president consistently initiated the conversations, which typically began with neutral topics such as work-related matters or comments on the complainant's social media status updates. Once the complainant was engaged in the conversation, the judge president would shift the tone and initiate sexual advances. The complainant will testify that, aware of the power imbalance in the relationship and fearful of potential repercussions on her career, she felt compelled to respond in a manner that would placate the judge president while simultaneously attempting to dismiss his sexual advances. Further testimony from the complainant will illustrate the persistent nature of the sexual advances, messages, and images she received from the judge president. Crucially, all of these interactions were non-consensual. While there may be minor inconsistencies in dates and chronology to the original complaint as made by the complainant, the evidence she produces will show that any inconsistencies only exist by mistake on part of her recollection. In fact, the additional evidence as retrieved throughout this tribunal process will prove that where she may have referred to an incorrect date, the messages bear her out as to the events which occur, albeit on a different date. The tribunal should therefore not be distracted by technical discrepancies that do not detract from the underlying misconduct of the judge president. This tribunal operates within an inquisitorial framework, not as a court of law, and as such, the standard of proof is based on a balance of probabilities as outlined in the Judicial Service Commission Act. In determining whether the judge president is guilty of misconduct, the tribunal must also consider the relevant provisions of the Judicial Code of Conduct. The Judicial Code of Conduct, the prevailing standard for judicial conduct which judges must adhere to, explicitly states that any willful or grossly negligent breach of the code may amount to misconduct which will lead to disciplinary action. Article 5 speaks to the requirement of judicial officers to act honorably and in a manner befitting the judicial office. The Code expressly notes and extends such behavior to the professional and private life of judicial officers and mandates them to act in a manner that enhances public trust in or respect for the judiciary and the judicial system. Article 5 specifically states that such conduct is to be assessed objectively through the eyes of a reasonable person. A judge's conduct is assessed by how a reasonable member of the public would view such conduct. Judges are held to a higher standard than ordinary employees. Therefore, the question that this tribunal must ask itself is whether, when viewed objectively, the JP's conduct, even if only that conduct to which he concedes, amounts to misconduct and a breach of the Code of Conduct for judicial officers. In making this assessment, the reasonable person includes a person working within the court and specifically those working in the division run by the JP. Additionally, the tribunal must consider whether a reasonable person would retain confidence in the honesty and integrity of the judiciary when a senior married judge engages in such conduct with one of the most junior members of his staff. In conclusion, the issue before the tribunal is whether the conduct of Judge President Mbenenge amounts to sexual harassment, gross misconduct, and an impeachable offense. The tribunal must assess this on the balance of probabilities, carefully considering all the evidence presented. The question the tribunal is faced with is whether it is suitable and appropriate for the Judge President of a division, a married man, leader in the community and church, and father figure to engage in the persistent and unwanted sexual conduct of a junior legal professional. The tribunal must also consider the significant power imbalance in the workplace, particularly between a senior figure like the Judge President and the junior employee, and how this power dynamic may have influenced the complainant's responses and a fear of reprisal, victimization, or job loss should she have rejected the advances. A consensual relationship, as understood under the law, is one that is explicitly stated, mutual, and unequivocally expressed by both parties. The complainant will testify that she never initiated any of the sexual advances, made repeated attempts to dismiss them, and even sought the courage to confront the Judge President by requesting a meeting with him. Her evidence will show that despite the repeated refusals, including an explicit denial of any desire for intimacy, the Judge President continued his sexual advances. On the Judge President's own version, at Volume 1, page 169, paragraph 50 of the tribunal record, he acknowledges that he may have been mistaken and apologizes for his conduct. At the very least, on his own version and admission of conduct through messages and the WhatsApp evidence of unsolicited sexual images sent by him, the Judge President has admitted to most gross conduct and to conduct that brings the judiciary into disrepute. Even the conduct admitted to by him is in direct contravention of the Code of Judicial Conduct as outlined in Article 5 above. It cannot be acceptable for a Judge President to persist with sexual advances when on his own version he was not sure that there was consent. Ultimately, a review of all the evidence will show that the Judge President's conduct clearly constitutes gross misconduct.
You seem to be burning to say something, Mr. Sikaka.
Burning. I'm not burning, but there were preliminary issues I had said I was to present together with the first one that has been determined. But I'm not burning.
Oh,
not
okay.
yet. Not yet.
All right. Not yet.
Not yet.
I think it's appropriate for us as tribunal to say that, let it be clear, this is not, what is right here is clearly comes from the lead of evidence. And let it also be made quite clear that at this stage, we do not necessarily agree with everything she's saying in a statement. That said, go ahead.
Thank you, Chair. We will let the case crystallize, and we will make our statement on the merit when the case has crystallized. The issues I wanted to raise, if one would call housekeeping, and they're not going to delay anything. It's just for the evidence leader to take note of because they're outstanding, but they're not for the panel. I think it's first is the fact that I think we've submitted our 2 files, which are the respondents' files. Secondly, they are outstanding. Issues, that is the witnesses to be subpoenaed, and that clarity, I think the evidence leader will know which ones are outstanding. We have no clarity as to that. Linked to that particular issue is a letter that is necessitated by a recent correspondence from Ms. Muretwa on the issue of witnesses, and we. That when they do that, because that also includes an issue of what necessitated by Ms. Muretwa's recent correspondence, the former CJ Raymond Zondo be subpoenaed, and also the other issue is what was unresolved was an identification parade, and where one doesn't know what happened to that. I think she was to do that. And then the other thing was the viewing of footage. There is no joint minute in this regard, but I think that can be talked about. And the tribunal, in our view, should view the footage itself. And lastly, that there are further downloads of cell phones that relate to particular dates. And I think the expert, I think it's Mello, will have to deal with it. So I'm raising that's for the dates, the 28th of June in particular, and the 18th of September 2022. 28th of June 2022 and 18th September 2022. Chair, I was raising this so that at least there is clarity about what is outstanding, but it does not delay the process. As to our opening statement, we will hear what the case is, let it crystallize, and we'll make our statement at the right time. And Chair, I just mean one thing. We do this about who's leading because in proceedings like this, the evidence leader does not represent the complainant. And we raise this because it's an important oversight in this country about what the evidence leader does. We raise these issues because the evidence leader does not represent the complainant, but helps this process, helps us, helps you crystallize the evidence. It's that old principle that a prosecutor, even a prosecutor, is not here to vociferously seek a conviction. So we raise this because most of the witnesses, in fact, all belong to her. She must lead them to assist this process. And we would require the list when it's finished. Can I just take a... My learned colleague reminds me that we will give a list of these outstanding things in a form of a letter. We will give it to the evidence leader, and the panel will get a copy thereof. Thank you.
We will deal with them as they come. Hopefully they will come with a full explanation so why you did not raise them all along and only raise them now.
We have. They were raised. That's why I call them outstanding.
Let me deal with one of them. You call them outstanding, and it may well be that it's somebody's fault that they're outstanding. We'll deal with each one of them if and when they come.
Thank you, Chair.
You refer 4 months ago, I asked the parties to submit list of witnesses shortly after or prior to the hearing. Your side in other words, your side was also asked to submit a list of witnesses. 3 or 4 months ago. You submitted them only last week. You gave reasons. There were reasons. I've seen some reasons, totally unconvincing and unacceptable reasons why you were not able to comply with the directive that you must submit a list of witnesses within that given time. I've read some flimsy reasons why the names were not given. So you need to be very careful when you try to suggest that there has been some neglect of duty on the part of the leader of evidence to arrange for the calling of witnesses. You submitted a list of about 10, 11, I don't know, hopefully not 100 witnesses, only last week. We did our best to issue subpoena and have them set on those witnesses as best we could, because you submitted the list only 2 weeks ago, or in fact last week. So we need to be very careful when you raise some of these issues. The tribunal is still, to this day, being owed an explanation, if not as a matter of courtesy, but certainly as a matter of law. Why many months ago we asked you to submit a list of evidence, and then your side, you're not in the matter, but the list was not given. As I repeat again, some unconvincing reasons were given as to why the list of witnesses could not be given. Not even one, not even two. I can tell you, after the Secretariat received your belated request for to subpoena certain witnesses, they contacted me, and we tried our best telephonically to try and meet your request to subpoena those people, and we did our best. So we need to be very careful before we throw stones here. There are a few other things that may still arise in the manner in which these proceedings were conducted, or in fact, accurately, failed to be conducted. As for these other things, Zondo and the like, we'll deal with them as they come. I'm not sure in what context Zondo should be subpoenaed. But as for the other things, the identification parade, I don't want to respond to that, because, except to say this, for you to know to conduct an identification parade, you had to know who was on duty on that day. For you to know who was on duty on that day, you must be given a date of the parade. It's an open issue as to whether or not we have got a particular date of whether a particular incident happened on this or some other day. These are the issues that we hope to deal with as we go along. We don't want to try to solve them in anticipation. The matter must be allowed to take its course, and we'll deal with those issues as they come. You may have to explain to me about the issue of subpoenaing the former Chief Justice. I'm not clear about it.
May I speak, Chair?
The context.
Yes, Chair. Chair, let me start here. The use of the word outstanding issues, and then I must address it to my learned friend, Advocate Skippers. It was not, these are issues outstanding. I did not intend to say she's not done her job. I was saying these are the issues that will be dealt with because we have in there outstanding. I communicated that I'm suggesting that she has not done her job. No, I can't speak for why issues are late. I'll take instructions, but I was not attacking her at all. I hear that the chairperson may have misconstrued the use of the word outstanding. It was not directed at her. So I can't answer for that, but I can answer for the fact that the lateness, I don't want to argue the merits of this point, but the lateness of the letter that seeks to subpoena the former Chief Justice is necessitated by another letter that has come from an official in that office who states certain facts that can only be ascertained with the former Chief Justice himself. But I don't want to argue the matter. I was just raising it. And I'm sorry again to Ms. Skippers if my raising of this issue was suggesting she hasn't done a job. That was not the message. Thank you.
Yes. You are going to, when the time comes, you are going to have to make out a case for the subpoenaing of the former Chief Justice.
I will, Chair.
It's not just there for the taking. You'll have to make out a case for it. And you'll have to consider the relevance of his evidence, the importance of his evidence to the issue that is before us. You'll be given the opportunity to do that in due course.
Thank you, Chair.
Advocate Skippers, we can proceed with the evidence.
Thank you, Chair. I think Advocate Raja Budlander would like to address the panel before we start.
Oh, okay.
Thank you, Chair and
There are always teething problems when a matter starts, so
Absolutely.
we will all have to be patient.
Yes,
Why?
absolutely. May I proceed, Chair? Thank you. My thanks to the Tribunal for permitting us to address you very briefly at the outset of these proceedings. I wanted to simply place on record our role in these proceedings. That has become even more clear just in relation to the submissions that Mr. Sikakane has just made when he raised the question of who represents the complainant in these proceedings. The simple answer, for the avoidance of any doubt, is that I represent the complainant, instructed by the Women's Legal Centre. But this is not a trial, and the Act here requires that the evidence leader's role is to collect the evidence and to present the evidence to the tribunal. That doesn't mean, in my view, that the evidence leader may not form view on the evidence that she collects, and there's a nuance here that one can debate and argue in due course to the extent that that's necessary, but I don't propose to do that, and I don't think that this is the moment to do that. What I simply want to say is the following. We have heard from the evidence leader, and on behalf of the complainant, we agree that under the Judicial Service Commission Act, the objects of the tribunal are to conduct an inquisitorial process and to inquire into whether the allegations against the judge president give rise to a finding on a balance of probabilities that he's guilty of gross misconduct. What that would require is for this tribunal to make findings of fact and to report on those findings to the Judicial Services Commission. So it is within the discretion of this tribunal to decide how these proceedings are to be run. We've heard already that, and we're aware that these proceedings are the first of their kind in South Africa, but it's not only the first of a kind, it is these proceedings concern sexual harassment, and we know that sexual harassment is a particularly nuanced, difficult issue to adjudicate because of the nature of the allegations and the impact that testimony has on both parties concerned. Sexual harassment is a form of violence against women in the workplace. So what happens during these proceedings in this hearing will send a message to South Africans about how the judiciary deals with sexual harassment and whether victims of sexual harassment in our courts feel confident about raising their complaints through this process. We accept fully that these proceedings today are to test the facts in this complaint and as they relate to the complainant and Judge President Mbenenge. But in our submission, it is important to record and recognize at the outset that this complaint does not arise in a vacuum, and that that context is relevant to how the evidence that this tribunal will hear in the coming days must be evaluated. This complaint happens in the context that sexual violence against women is pervasive in the legal profession, and more broadly.
I don't understand what you're talking about, Advocate Butland. We're here to hear a particular complaint, a particular issue. We have been enjoined by the JSC to come and address a particular issue. I'm not sure what you're talking about.
Chairperson, what I'm asking this tribunal to be evaluated, the evidence that is presented to you, happens in a context. One must be aware of that context, and one cannot pretend that this is simply...
But we will do so when the time comes.
Yes, I have no
There's
doubt.
no evidence before us. How can we evaluate evidence? I'm desperately trying for us to get started and hear the evidence. I'm not so sure what your problem is, quite frankly.
No, Chairperson, I don't have a problem, but I am here representing the complainant. The complainant in a process such as this does not have her own voice in the process. To that extent, what I was getting to was that the Act requires that the evidence leader will collect the evidence and present that evidence to this tribunal. I will not be leading witnesses. I will not be cross-examining witnesses. This is the opportunity that I have to address this tribunal, and I thank you for that. On behalf of the complainant, we simply wish to say that this process, we ask that this process takes place in a way that is cognizant of the context in which it comes to you, and that it respects and protects her rights to be treated in a respectful manner during these proceedings. And let me be clear, I am not suggesting at all that this tribunal will not do so, but I simply wish to place that on record. Our role then, and the Women's Legal Centre's role, they deal with complaints of this type on a daily basis. And so as we see our role, it's to provide support to the complainant and to be available to the tribunal to the extent necessary. And so in due course, what we will ask this tribunal to permit us to do is to make oral and or written submissions at the end of the evidence to contextualize the complaint and the evidence. Those are the only issues I wanted to raise, Chairperson. It's nothing more than that. I thank you for the time.
I may have to assure you about something. Consult with members of the panel. Advocate Butland, it may well be that after the lead of evidence has led the evidence, it may well be that I'm trying to address a concern that seems to be there at the back of your mind. It may well be that you may be given the platform to put questions to your client if you feel there are certain important aspects which the lead of evidence didn't cover, which you would like to cover with your client. Does that address some of your concerns?
Chairperson, it's not really a concern of mine. I have full faith in the evidence leader. Our bigger concern is that this is the process that all complainants will face in similar matters. And not all of them will have access to pro bono legal services or the Women's Legal Centre. So it is important to us that this process runs as the Act anticipates that it will run. And we thank you for that opportunity. I'll take instructions. And if you would permit me to raise that issue down the line, should we need to ask questions. It wasn't necessarily an enormous question at the back of my mind, because we do, as I say, have full faith in the evidence leader in running this process. Thank you.
Well, I'm putting that to you because in the context that earlier we asked the parties, the legal representatives, to lead their own clients. And the respondent's choice was that he would like to be led, would like his evidence to be led by his legal representative. So one would imagine that you could easily have said so yourself, but you prefer to rather use the lead of evidence. That being so, raises the possibility for you, once the lead of evidence has finished, if you feel that from consultation you have had with your client, there are certain areas which have not been properly covered, then you can do so, provided it will be, of course, before the cross-examination.
Thank you very much, Chair. We appreciate that.
Is there something else again before we start?
Chairperson, if I may just for certainty, according to the rules regulating the proceedings here today, Rule 7, Sub-Rule 2 says the evidence leader may then examine the witnesses which he or she intends to call to prove that the respondent is suffering from an incapacity, is grossly incompetent, or is guilty of gross misconduct, and may adduce such evidence as may be admissible. And relate with that, 7 Sub-Rule 5, the respondent may examine the witnesses which he or she intends to call to refute the allegations against him or her, and may adduce such other evidence as may be admissible. So I hear what Advocate Sikakani is saying now, that they want me to call their witnesses. But according to the proceedings, the evidence leader's role is to lead all the evidence to prove the complaint, and the respondent's legal representatives must lead the witnesses to refute the claim. The problem is I haven't consulted with their witnesses because they are actually not my witnesses, and I will not call them to prove the case. So I just need clarity on that.
Let us not run ahead ourselves. Those witnesses may be there, they may not come. Let's not spend time talking about witnesses which are not before us. We will deal with that part when it comes. Let us deal with what is here in front of us now, please. In any event, the rule or the act says the tribunal has the power to determine its own procedure. So we have got the power to determine our own procedure as to who should stand up and who should sit down, who should speak, who should shut up. We have got that power. We'll deal with those things, please. Now, somebody must speak up now. Let us hear the evidence. Please, shall we get started?
We can start, Chairperson. I would like to then call the complainant to the witness stand, Andiswa Mengo. She will be assisted by an interpreter as well, a Xhosa interpreter.
Your full names, please. Your full names, please. All right. Before you sit down, let us just go through one step. Do you have any objection against taking an oath?
Phambi koba siqhube ndithanda into okokuba sithathe ke isifungo. Ingabe unengxaki nokufunga?
Andinaso, mhlali ngaphambili.
No objection, Chair.
So if that's the case, do you swear that the evidence you're about to give will be the truth and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
Kuba kunjalo ke ingaba uyafunga uba ubungqina bakho buya kuba yinyani, inyaniso yonke, inyaniso yodwa. Uba kunjalo uphakamise isandla sakho sase-right uthi ndincede Thixo.
Ndiyakwenza njalo ndincede Thixo ndithethe nyani.
Sworn Chair.
Yes, you may be seated now.
Ungahlala phantsi.
And if you can, please try to. If you can, please try to speak as loudly as possible. Don't just whisper to the interpreter. Speak loud enough so that we can all hear, and those who understand, this it goes as well. So that, importantly, your legal representative should hear you and should be able to tell whether what is being interpreted is accurate or not. But if you don't speak loud enough, they may not be able to pick that up. Are you having some touch of flu? It seems that you struggle with your voice.
Ukuba unako ke isicelo sithi sicela uphakamise ukuthetha, uthethe ecacileyo khona ukuze wonke umuntu olapha akwazi ukuva, nalowo uzawuba zindlebe zakho okanye okumeleyo akwazi ukuva ngokupheleleyo ukwenzela into yoba naxa itolikwa kufumaniseke into yoba kutolikwa kanye le nto ubuyithethile. Nantsi ke enye into ayiqapheleyo umhlali ngaphambili indaba yelizwi lakho. Ufuna uqonda uba ingaba mhlawumbi ikhona ingxaki, ingaba unefiva okanye kwenzeka ntoni?
Andinangxaki nelizwi lam, ilizwi lam lincinci ngendalo.
Okay.
Kodwa xa lingabe li-strained liye libe nokuthanda ukutsha, kodwa ke ndawuzama uba ndikhwaze ndivakale.
I do not have any specific issues with my voice, Chair. I'm not fluish either. However, this is the sound of my voice. It sounds squeaky, and especially if it becomes strained, then it totally goes out. How will I ever indicate when such takes place?
Yes. Thank you. Advocate Skippers.
Thank you, Chair. Ms. Mbenenge, at the time when you laid this complaint, you were a judge's secretary at the Mkanda High Court in the Eastern Cape. Is it still the position? Are you still a judge's secretary stationed at the Mkanda High Court?
Ngethuba wawufaka esi sikhalazo, wawungunobhala wejaji okanye ke singathi usekretary ngolwasemzini eMakhanda High Court. Ingaba kusenjalo?
Kusenjalo, mhlali ngaphambili.
That is still the case.
When was Makanda your first station where you were appointed?
Ingabi Makhanda le sisitishi sakho sokuqala apho wawuqeshwe khona okokuqala ngqa?
Kunjalo, mhlali ngaphambili.
That is correct, sir.
And when you were appointed there as a judge at that stage,
Ngexesha wawuqeshwa khona apho njengosekretary, yayingowuphi unyaka, ingubani ujaji owusebenza phantsi kwakhe?
Qala bendingumncedisi kula section okanye kwela candelo ukusukela ngo-2018.
At first, I was an assistant in the section from the year 2018.
Ndiye ke ndaba sisigxina ngonyaka ka-2019 and
I was then permanent in the year 2019.
and uJudge President ngelo xesha yayinguJudge President Sangoni.
And at the time, Judge President was the then Judge President Sangoni.
Have you ever been the secretary of any of the judge presidents that you worked under?
Wawukhe wanguye usekretary okanye unobhala womnye we-judges owawuphantsi kwazo?
Uthetha mhlambi oJudge President noba just mere judges.
Do you mean specifically judge presidents or just any judge general?
Specifically judge presidents.
Uthetha kanye ngo-judge presidents. Ukhona okhe waphantsi kwakhe wangusekretary wakhe?
Andizange, kodwa lukhona usuku olunye endandicelwe ngalo uba mandincedise uJudge President Sangoni.
I have never, however, there was a particular day specifically where I was requested to assist JP Sangoni.
Now, when you were working and Judge President Sangoni was the acting, JP at that stage, how did you communicate with him? On what platform? If I can put it like that.
Ngela xesha ke wawuncedisa uJP Sangoni ngela xesha wawunxibelelana njani naye, wawusebenzisa ntoni ukuzama ukunxibelelana naye?
Ndandithetha naye ngokudibana in person kwi-chambers.
I would speak to him or communicate with him in person by meeting him in chambers.
Is that the only way of communication that you had?
Kuphela kwendlela leyo ubunayo yokwazi ukunxibelelana naye.
Injalo.
That is correct.
When did the respondent in this matter, when was he appointed as the judge president in the Eastern Cape?
Lo ke onesikhalazo ngakuye usingaye ngamanye amazwi, uqale nini yena ukusebenza njengo-judge president eMpuma Koloni?
Andiqinisekanga ngonyaka awaye-appointwe ngawo.
I am not certain of the year of his appointment.
And when he was appointed there, initially, how did you communicate with him at all?
Eqeshweni kwakhe khona apho ke eMpuma Koloni, uke waba nalo unxibelelwano naye ngaphambi koko? Ngaphambi kokuqashwa kwakhe?
Phambi koba benguJudge President ebeyijaji, andizange ndithethe naye. Nangoku sele eqeshwe as uJudge President nge-early stages okanye kumaxesha angaphambili before thina sithethe, khandithethe naye.
I had not had any communication with him even before he was appointed as a judge president. And during the early times of his appointment as a judge president, I had not had.
Ewe, ndive kakuhle sesenkosi.
That's correct.
I'm speaking about the respondent here today, Judge President. I'm speaking about the respondent here today, Judge President Mbenenge.
Mamela ke, sithetha ngo-judge president lo esiphambi kwakhe namhlanje uJP Mbenenge. Thetha ngaye.
And I don't know if you don't understand my question. I'm not asking you if you initiated the communication. Was there communication between you and the respondent?
Andazi ke noba undive kakuhle na, andithethi ngohlobo lokokuba mhlawumbi kuthiwe nguwe oqala incoko okanye oqala unxibelelwano naye. Bendifuna nje uqonda uba uke wanalo nithuba apho nike nano elelwano na yena uJP Mbenenge?
Ewe sikhe sanalo.
Yes, we've had communication.
And in the beginning, when you just started there as the judge president, how did you communicate? On what platform, if I can put it like that?
Ngokuya wayeqala esebenza njengo-JP uJudge Mbenenge. Niye nanalo njani unxibelelwano? Luqale njani kuni nobabini?
Ngoku beqala andikhumbuli kakuhle uqala kwakhe ngoku aqalayo uba ngujudge president. Kodwa ukuthetha kwethu ibikukuthetha kwaxa sibonana. Mhlawumbi kukho loo nto ayidingayo.
When he started, initially, I do not recall having any communication with him. However, when there is such, it will be a situation of us meeting and talking. That will be it. When we see each other, rather.
So does that mean in person?
Ingaba ithi loo nto benithetha xana ngabana nibonana nje umntu ubuso ngobuso.
Kunjalo.
That is correct.
And how was your relationship in the beginning? Was there any problems between the two of you? Or what is the position?
Bebunjani ubudlelane phakathi kwenu nobabini ekuqaleni? Ezikhe zakhona ingxaki mhlawumbi phakathi kwenu nobabini ekuqaleni?
Hayi zange kwabakho ngxaki.
We had never had problems.
And just for clarity, you say you are appointed as a judge's secretary in Mkanda. Do you only work in Mkanda High Court, or what is the position?
Uthi uqeshiwe njengosecretary wejaji eMakhanda. Ingabe usebenza eMakhanda kuphela okanye isebenza njani lento?
In i-headquarters, ndicela uxolo ngokuthi i-headquarters nge-English, andiyazi ngesiXhosa. I-headquarters yi-Grahamstown, which is Makhanda High Court, kodwa siye siphume siyosebenza kwezinye indawo.
The headquarters, my apologies for mentioning the English word. I do not know what it's called in isiXhosa. The headquarters, it's basically Grahamstown. There will be times where we will go out and work outside of Grahamstown.
And where is the judge president stationed?
Judge President lo yena uphi apha khoyo?
Bekufanele uba nezakhe i-headquarters yiMakhanda.
It is supposed to be, his headquarters is also supposed to be Makhanda.
If you say his headquarters is in Mkanda, does he only have an office in Mkanda, or is there other places that he also has offices?
Xa usithi i-headquarters zakhe iMakhanda, bekumele uba une-office eMakhanda okanye i-office akuyo ngoku uyakwazi uba abe ulapho nangona uNdlunkulu useMakhanda?
Unayo i-office eMakhanda, unayo i-office nakwezinye courts.
He does have an office in Makhanda. He also does have an office in other courts.
Can you name these other courts?
Zeziphi ke ezinye ezi inkundla ozikhankanyayo khasichazele?
Inkundla ephakamileyo yaseGqeberha.
It's the Port Elizabeth, or rather Gqeberha High Court.
Inkundla ephakamileyo yaseBhisho.
High Court Bisho.
Inkundla Local Division, which is it's a circuit court in East London.
It's also a circuit court in East London,
Nenkundla ephakamileyo eseMthatha.
as well as the High Court in Umtata.
Are these also the courts that you worked as a judge's secretary as well?
Ingaba ezi nkundla ke uzikhankanyileyo nazo zinkundla ukhe uye ukusebenza kuzo njengosecretary?
Kunjalo.
That is correct.
Now, You said initially you did not really interact with him or communicate with him, but if you did so, it was in person. Did that at any stage change?
Ubukhe wathi apha ubungenguye umuntu ubuye ube nonxibelelwano naye kodwa ibe ithi biyenzeka loo nto yenzeke nithethathethane ubuso ngobuso. Ike yenzeka leyo nakwesiphi na isigaba sokuba nibe niyathetha ubuso ngobuso?
Ewe yenzekile.
Yes, that happened.
What was the circumstances at that stage and why did it change?
Iimeko bezinjani ngelo xesha yaye yintoni eye yabangela into okokubana kube khona utshintsho?
Kuqala ukuze sibe asithethi ngokubonana uze yena andifowunele.
Firstly, when it happened to, or when it got to a level of us not talking in person, uqale yena wakufowunela.
Ewe nguye oqale.
He first called me. Qhuba.
Just explain, why did he call you?
Khawucacise ukuba yintoni isizathu esabangela into bakufowunele.
Undifowuna kuba kwakukho ingxaki yodushe olwalukhona eMakhanda ngela xesha.
He called me because there was a to sit on that particular Tuesday.
Uxelelwe ke ngomnye wo-advocate.
He was therefore informed by one of the advocates
Ukuba ukhona umuntu esicinga uba angasinceda esimthembileyo.
that there is someone that we highly trust, that we believe could assist or could be of assistance.
And kuba nalomntu uzawukwenza le motion court ngumntu oyijaji.
And as well as the fact that this person that will be running this court is a judge.
An acting judge, to be specific.
Ukucacisa ke ibingujaji wethutyana obambeleyo.
Yabe nabo bona bengamagqwetha beze necebo loba ingenziwa virtually.
And as them in a group of lawyers, they were then able to suggest that this could be conducted virtually.
Uye ke lo advocate lo wamnika inamba yomntu lo bathi bamthembile ke kuye kwacaca uba ndim ke lo.
And that particular lawyer then granted him or gave him the number of the person that they trusted, and it became clear that that person was myself.
So just to be clear, your number was given to the respondent by someone else and he called you.
Ukucacelwa nje kule ndawo uthi inombolo yakho yanikwa lo ummangaleleyo uba makakufowunele.
Kunjalo mhlali ngaphambili.
That is correct, Chairperson.
And according to the papers of the complaint, that was in May 2021, the 25th of May 2021.
Ngokwamaphepha ke inyanga nonyaka yayinguMeyi kumnyaka ka-2021.
Kunjalo.
That is correct.
So did the respondent ultimately call you?
Ingaba ke kwenzekile njalo lo mmangaleleyo wakufowunela?
Kunjalo.
That is correct.
And I suppose arrangement was made and the virtual hearing then proceeded. Is that correct?
Ndizawucinga uba kamalungiselelo aye enziwa lwaze ke udliwano ndlebe olo lwaqhubeka.
Ewe nam futhi ndamqononondisa uba ndiyakwazi ukwenza i-court online and ne-link izawuthunyelwa ndim.
Yes, indeed, it proceeded, and I assured him that I am capable of conducting a court online and I will make sure that I will be the one handling the link that I'll be sent.
Except for the arrangements that was made between yourself and the judge president, the respondent in this matter, did the conversation go around something else as well?
Ngaphandleni ke kwamalungiselelo la nanithethathethana ngawo nalumangaleleyo, ingaba incoko le yaye yajika mhlawumbi yangenye into engenye?
Hayi, zange ijike ngalaa mini.
No, that day the conversation never changed.
All right, so this virtual hearing then happened, and then an incident happened between yourself and the court manager. And I don't want you to go into details of that incident because that's not relevant to this hearing. What happened after you had this interaction with the court manager? What did you do?
Yenzekile ke le yalento yodliwanondlebe lu virtually, kwaba khona into eyayikhona phakathi kwakho no court manager, kodwa kandifuni uba singene nzulu ke kuleyo, kodwa endifuna ukukwazi ukuba kwenzeke ntoni phakathi kwakho no court manager.
Ndicela ukuqala ndithi phambi kokuba kwenzeke loo nto yenzekayo phambi kwam no-court manager, kwanyanzeleka uba mandibe in person kwi-court building ngoba u-acting judge lo wayedinga isapoti.
Mike, if I'm allowed, may I please start by saying, before I get into the details of what happened between myself and the court manager, I was needed to be in the building in person because the acting judge at the time needed assistance.
All right, I don't want you to go into what happened between yourself and the court manager.
Mamela.
There was an incident, and then what happened between yourself and the respondent as a result of this incident?
Akafuni singene ke nzulu kwimcimbi ukuthi kwenzeke intweni phakathi kwakho no court manager. Kodwa funa uyazi okokuba kwaye kwenzeka ntoni phakathi kwakho nalo ommangaleleyo. Urespondent ngamanye amazwi asemzini.
Ngeliphi ixesha?
At what time?
In your papers, you said on the 28th of May 2021, you spoke to the respondent.
Mamela ke, kumaphepha wakho uthi ngomhla we-28 kwinyanga kaMeyi kumnyaka ka-2021. Ufuna into eyenzekayo ngolaa suku.
Ndisemsebenzini ngale mini.
I was at work on the date in question.
Ndimbonile naye uba ukhona.
I saw him as well, that he is present.
Sorry, can I just stop you there? You say you were at work. Where were you at work?
Uthi wawusemsebenzini phi kweyiphi indawo?
Emakhanda.
In Makhanda High Court.
Yes.
Qhuba.
Kuba bendiqala ukumbona emveni kwe-motion court day.
Because I was now seeing him for the first time after the emotion court day.
You are now speaking about the respondent.
Uthetha ngalummangaleleyo.
Kunjani?
That is correct.
Yes.
Ndacinga into yoba kurayithi uba ndiyokumxelela iziphumo.
I thought that it is the right thing to do to go and inform him of the outcome.
Yes.
Ndiyile ke ndankqonkqoza.
I proceeded and I knocked.
Where did you knock?
Unkqonkqoza phi?
Phaa kuye kwi-chambers.
At his chambers.
Yes.
Ndafika ke usekretary wakhe ehleli ejonge efestileni.
I found his secretary seated, looking through the window. Qhuba.
Wabe endibona uba andikho rayithi kwalapha ebusweni.
The secretary could see that I am not all right from my facial expression.
Ndacela ungena.
I requested to come in. Yes.
Zange ndi-escorte ke aqala ngene atsho kujaji uba kukho umntu omcelayo wathi mandizingenele.
She did not escort me to the judge so that she could inform the judge there is someone who would like to see him. She just said I should proceed on my own.
Ndingenile ke ndabulisa. Ndacela uhlala phantsi ndahlala.
I indeed proceeded. I greeted and I requested to be seated. I sat down.
Ngelo xesha ke besendibulila.
At the time, I was becoming emotional. Yes.
Ndamxelela uba kwenzeke ntoni ngoLwesibini.
I informed him or narrated to him as to what happened on Tuesday.
That is now what about? What did you inform him about? About the court proceedings or about the incident between you and the court manager?
Umchazela ngantoni ngenkqubo yenkundla okanye umchazela ngalento yenzekileyo phakathi kwakho no-court manager?
Zombini.
Both incidents.
Why did you inform him about the incident with the court manager?
Kwakutheni uze umchazele ngalento yehlayo phakathi kwakho no-court manager?
Ndandimxelelele okokuba ayazi, in fact wayeyazi uba azandiziyele. Ndandiceliwe and naye wabe eyiphathi yaloo nto.
I had informed him because I needed him to know, as this was not voluntarily that I had gone there, he was part of the whole process as well. Yes.
Ndimchazele ke kodwa wabe esithi uzawuthetha naye u-court manager ngoba uyabona uba ndiyakhala.
I informed him. He then mentioned to me that he will have a word with the court manager as he could observe that I am crying.
After you informed him about the incident with the court manager, did you leave his chambers then?
Emveni kokuba uye wamchazela ngalento yenzekileyo phakathi kwakho no-court manager, uye waphuma wahamba wena apha eofisini yakhe?
Ewe ndihambile ndabuyela eofisini yam.
Yes, I left. I went back to my office.
Yes, you may proceed.
Qhuba ke.
Kulaa ndawo bendihlala kuyo, kulaa office bendikuyo, bendiprinta kumnyango endihlala kuwo ngoku, opposite iofisi yakhe.
Buprinta khona.
Bendiprinta kulaa printing nkulu iphaa.
In the office that I occupied, which I still occupy, when I need to print, I would print at a door opposite. Uthi opposite ubani?
Opposite umnyango ka-Judge President.
I would print at an office that has a door that is opposite the Judge President's office. Yes?
Ndithe ndisiza ke epasejini.
As I was approaching or being down in the passage,
Ndabona u-court manager esiza naye kwelinye icala.
I saw the court manager also approaching from the other side.
Yes.
Yena ke bese kufutshane apha kulomnyango ka Judge President mina ndisekudana.
The court manager was quite closer to the judge president's door. I was a bit far from the door.
Ungenile ke yena mina ndashaka ndingena apha kulomnyango ndizothatha kuwo iphepha endiliprintileyo.
The court manager then entered the office. I ended up getting into the office where I print to collect the paper that I had printed.
In which office did the court manager enter?
Court manager lo ungena kwiphi office?
Ke office ka Judge President.
The court manager entered the judge president's office.
Yes.
Andilithathanga ke liphepha kuya kwakho into othi mandiphume ndingene pha.
I did not take this paper that I had printed. Something in me said I should enter the office.
Which office?
AP of
Le ka Judge President.
the judge president's office.
Ndiqaphele ke noba usecretary lo wakhe akasahlelanga kulaa ndawo ebehleli kuyo ngokuya bendizile akekho.
I also noticed that the secretary is no longer seated where she was when I had come to the office. She's not there.
Eyesibini into endiqapheleyo kuba lo mnyango ungena apha kuye kwi-chambers is not properly closed. Awuvalwanga ncam.
Also, what I noticed was that the door that goes into the judge president's office or chambers was not properly closed.
Ndithe xa ndijonga ndafumanisa uba nabaya bayahagana.
When I looked, I then saw that there they are, hugging one another.
Did you hear anything that was said?
Ikhona into owakwazi uyiva eyayithethwa.
Azange ndive nto. Ndatsala umnyango qha ndaqonda uba ndifuna babone uba ukhona umntu obelapha.
I did not hear anything. I just pulled the door closed because I wanted them to realize that there was somebody that was there.
Sorry. Could this be the convenient point at which we could adjourn for lunch before we go beyond the door? We will adjourn until 1:45,
Siza ke sinqumame ke
unless
kancinci,
there is some objection.
sibuye
No,
ngokota to
there is
2.
no objection.
Ukhona umuntu onengxaki? Akekho.
And by the way, you are still under oath and you worked at the court. I mean, you know the rules. You don't have to consult or talk with anybody about this matter because you are still. No, you're not under cross-examination.
No.
Well, Patrick Machawa. It was instructions from my left, and they are not correct. So I think you can talk to anybody, quite frankly.
Ungathetha naye
Yeah.
noba ngubani na.
My legal team.
Noted, Chair.
Cool, we'll do so.
Yes, we are reconstituted. And Ms. Mengo, you were still giving evidence. And, can you proceed, please?
Thank you, Chairperson. All right, so we're still on the day of the 28th of May 2021. You said that you closed the door. Did you receive any feedback from the respondent about the complaint about the court manager?
Siphele apho ke ubuchaza mayelana nomhla we-28 kwinyanga kaMeyi kunyaka ka-2021 apho waye wavala khona ucango. Ikhona mhlambi into owaye wayifumana efana nengxelo uyifumana ke kulo ummangaleleyo ngokwesikhalazo sakho ngento eyenzeka phakathi kwakho no-court manager?
Ayizange ndifumane ngxelo kuye.
No, I never received any feedback from him.
Did you continue with the conversation or with conversing with the respondent after this incident? Or how long after this incident did you first have another interaction with him?
Ingabe uqhubekekile nokuncokola naye lo ummangaleleyo emveni kwesehlo esi okanye ikuthathe ixesha elingakanani phambi kokuba uphinde uqhubekeke nencoko naye lo ummangaleleyo?
Ndiqhubekekile ukuthetha naye in person.
I continued speaking to him in person.
What I'm asking is, this was now the 28th of May. When was the next time that you had a conversation with him? Either in person or any other way?
Afuna ukuqonda ke uthi njengoba sinalo mhla we-28 kaMeyi ku-2021 uphinde wathetha naye nini lo ummangaleleyo? Noba nithethe ubuso ngobuso okanye mhlawumbi usebenzise enye indlela yonxibelelwano?
Ndicinga uba bekupha koJune.
I think it was around June.
Yes, just explain to us what happened.
Qhuba ke kwenzeke ntoni?
Nanjengomntu yena ophethe la division.
As someone who is in charge of the said division,
And mna ngelo xesha ndandingumntu oncedisana nojaji osenior eMakhanda ngelo xesha.
and myself being someone who was assisting a judge who is senior in Makhanda at the time.
Sorry, is it 2021 or 2022?
2021.
June
June
2021.
2021, yes.
Thank you. Sorry to interrupt.
Uyaxolisa ke umhlali ngaphambili ngokuphazamisa.
And according to your papers, it was on the 8th of June 2021.
Ngokwamaphepha wakho ke yayingomhla wesibhozo kwinyanga kaJune unyaka ingu-2021.
Kunjalo.
That is correct?
Yes, what happened there?
Kwenzeke ntoni?
Ungenile engena kule office ndiphangelela kuyo nalo senior judge.
He entered in the office where I work in with this senior judge.
All right, if you say he entered, you must explain to us who entered.
Xa usithi ungenile, sifuna ungqale ngqo uchaze uba ngubani lungenileyo.
Judge President Mbenenge ungenile kule chamber ndisebenzela kuyo.
Judge President Mbenenge entered the chambers where I worked in.
Unke ecela wabuza kuqala uba ukhona na umama wam.
Upon entering, he asked as to whether my mother was present.
Why did he ask that, or just explain to us that context?
Kutheni lento ezawubuza loo nto, khawusicacisele ngayo yona loo meko.
Kwayena uthi thina masithi ijaji esisebenza nazo ngomama bethu notata bethu if usebenza nojaji oyindoda.
He is the very same person that would say, when we work with female judges, we should refer to them as our mothers, and if we work with the male judges, it's our fathers.
Naye ke xa ethetha ngabo ethetha nomnye umuntu okanye nam wayethethela kuloo nto uba ukhona na umama wam.
He was then referring, when he was talking to me, exactly to that when he asked as to whether my mother was present.
Referring to the judge.
Uthetha ngojaji.
Uthetha ngojaji.
That is correct.
Yes, continue.
Qhuba.
Unqonqozeka yi-1 ke wavula umnyango wangena phakathi phaa kwi-chamber kajaji.
He knocked once, opened the door, and entered the judge's chambers.
Ngoku angenayo kuqala apha kule ofisi yam ke ndicela uyicacisa uba apha emva komnyango kwakuhleli umntana wam kwi-couch.
As he entered, if I may explain this part, as he entered, behind the door, there's a couch, and my child was seated on the couch.
Akambonanga ke ngoba ngeli xesha angenayo bengajonganga kweli cala lisemva kocango.
He did not see the child when he entered, because when he entered, he did not look towards the direction of the back of the door.
Uhlalile ke for ixeshana apha ngaphakathi nojaji bevalile.
He remained for quite a while or some time inside the direction, and the door was closed, the back of the door.
Yes.
Uphumile ke emzuzwini.
After a while, he came out.
Xana apha ngaphakathi nojaji bevalile.
He remained for quite a while or some time
Wabona ke
inside
umntana
the
lo,
direction,
ngoku xa
and the
ephuma
door was
komnyango,
closed, the back of the door.
Amehlo wakhe angqamana nale ndawo umntana
Yes.
mebehleli kuyo. Uphumile ke
Came
emzuzwini.
out. Then after a
Uhlale-
while, the child came out.
Xana apha ngaphakathi nojaji
Coming out
bevalile.
of the judge's He remained for quite a while or some time
Wabona ke
inside
umntana
the
lo,
direction,
ngoku xa
and the
ephuma
door was
komnyango,
closed, the back of the door.
Amehlo wakhe angqamana nale ndawo umntana mebehleli
Yes.
kuyo. Uphumile ke
Came
emzuzwini.
out.
Ubuza
Then
ke,
after a
uhlale-
while, the child came out.
Xana apha ngaphakathi nojaji
Coming out
bevalile.
of the judge. He remained for quite a while or some time
Wabona ke
inside
umntana
the
lo,
direction,
ngoku xa
and the
ephuma
door was
komnyango,
closed, the back of the door.
Amehlo wakhe
asked that
angqamana nale ndawo umntana mebehleli kuyo. Uphumile ke
Came
emzuzwini.
out.
Ubuza
Then
ke,
after a while, the child came out.
Xana apha ngaphakathi nojaji
Coming out
bevalile.
of the judge. He remained for quite a while or some time inside the direction, and the door was closed, the back of the door.
Amehlo wakhe angqamana nale ndawo umntana mebehleli kuyo. Uphumile ke
Came out. Then after a while, the child came out.
Xana apha ngaphakathi nojaji bevalile.
The judge. He remained for quite a while or some time inside the direction, and the door was closed, the back of the door.
Amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, facing back inside the direction. The door was to the back of the door.
amehlo wakhe angqamana nale ndawo umntana makayixelele ke uphumile ke
Came out. Then after a while, the child came out. The judge remained for quite a while, for some time, time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. Came out, then the child came out. The judge remained for quite a while, for some time facing that inside the direction, the door was to the back of the door. which came out with remained for quite a while. Some time facing back inside the direction the door was to be back of the door. And then came out with remained for quite a while. Some time facing back inside the direction the door was to be back of the door. And then came out with remained for quite a while. Some time facing back inside the direction the door was to be back of the door. And then came out with remained for quite a while. Some time facing back inside the direction the door was to be back of the door. And then came out with remained for quite a while. Some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with some time facing back inside the direction the door was to be back of the door. And then came out with Mbenenge
We only